so, because I have all these videos in here, so I think it's a better idea to not do it. Where's the sound volume, just so I know? Okay. Okay. Well, we're talking about my favorite subject, police interrogation, and I really, truly love it. And what I'm curious about with you guys is how many of you really love to try confession cases? Okay. What I'm hoping is that when we get to the end of this presentation, that you're actually going to look forward and enjoy trying confession cases, because it's like anything else. Once you learn how to do it, the whole subject just really opens up for you. You know, I must have spent at least the first 10 years or so of my public defender career thinking, if there's a confession, the case is impossible to try. So I started out with that idea. I started, you know, I'm ancient. I started practicing in 1980, and that was also before all this research on false confessions had been done. It was before DNA evidence. In the 1990s, people started to research the false confession phenomena. There started to become DNA exonerations, and that really changed a lot of things and opened my eyes up. But there's a woman on the faculty here named Andrea Lyons. Some of you may have heard of her. She came to Milwaukee in the late 80s, and she did, or early 90s, and she did a presentation for us on how to defend a confession case. She was out of Chicago, and her presentation centered around the fact that the police beat her client up. It was very Chicago. You know, the Baker case is a very old Chicago case, and this kind of threat to beat somebody up is very typical of what happened. But that's not what modern police interrogation is about. It's not. Okay. Really don't grasp the political way is to say, that's not really true. But that's not what that's not really the way that police, because interrogation principles of making the police officers, making the suspect, police officers, and so the interrogation of job interrogation is probably understand when I'm going to a room and searching hours later. I want to know how many of you have reported interrogation practice. Half, and the rest of you don't. And I work for your name. Is reading interrogation in 1936 when you read that case. The group was a group with polygraphs. They also psychological lessons of interrogation as people who not be practice. That was the reason in their school. They have a book that you in it. State practice, information, investigator tips, critics exploring. This book, if you want to buy it, it's from Amazon.com. I had how to read for famous for polygraph. If I was a famous opponent of the Miranda decision went for a long time. Is that the Miranda decision taught the resource of it is. How becoming as embodied in Reed, the right to have lawyers so they have some defense against. So this is around the time. Fourth, they had to acknowledge that Paul was irrefutable. The fourth edition came out, I don't know, maybe the book, but the core of the Reed technique of police interrogation method. Police interrogation is partly premised on of being able to catch a liar. Okay? Research what way worse than statistics share with you. Average police intelligence percent of the is just so no. There are people who will not be proud. That was the reason in their school. They have a book that you are in it. State practice, information, investigator tips, critics exploring. This book, if you want to buy it, it's from Amazon.com. Had how to read for famous for polygraph. If I was a famous opponent of the Miranda decision went for a long partly premised on being able to catch a liar. Okay? Research what I way worse than just to share with you. Average police intelligence is just so no. They're people who will be the crowd. That was the reason in their school. They have a book that you in it. Safety practice, information, investigator tips, critics exploring. This book, if you want to buy it, it's from Amazon.com. Had how to read for famous for polygraph. It was a famous opponent of the Miranda decision. Miranda decision went for a long time. Is that the Miranda decision taught the resource of it is. Well, because as embodied in Reed, the right to have lawyers for the defense against. So this is around the time. Fourth, they had to acknowledge the fault was irrefutable. The fourth edition came out, I don't know, maybe the book, but the core of the Reed police interrogation method. Police interrogation is partly premised on being able to catch a liar. Okay? Research what way worse than just to share with you. Average police intelligence is just so no. They're confident. They have individual truth for them. So back to them. Their technique is interviewing people, deciding one side on officers in their case telling the truth or not. Show that the police the truth. They run as however, their truth down to the high 40s. So actually, using this ability to analyze, and I'll explain why in a minute. Okay. So the Reed technique is based on 3 separate sections. They would be 2, I say 3. A behavior description interview, I'll explain in a minute. That's where they interview the person. This is not an interrogation. Vague questions and the 9 steps. Now, how many of you guys have planned to put the CD into your laptop yet? You know, all the materials for the faculty? I do believe that I have an outline on there, but if there isn't, you can email me, and I'll just email you the outline. You can also, if you really dug around, found it on the Wisconsin State Public Defender website. But I'm happy to share written materials, taking notes. And not that you don't have, I mean, you can if you want to, but this outline if you have really good. It doesn't have a PowerPoint, it's actually a lot more thorough. So I'm just letting you know if you don't, I'll give everyone my email address. It's VISHNYD. Actually, it's in that. So I'll be at OPD.gov. All of that, don't you? Addresses, phone numbers, and email. if you don't feel like writing, you don't have to. All right. Then they go to a vague question, which is basically making the feel like a huge amount of evidence against it. And then they call the 9 steps of interrogation. When talking about all 3 of these things, it's possible in many places, but sometimes they do. So what is the behavior description? It consists of 17 questions that must be asked. And in my outline, I have all 17 of them written down. But a lot of these questions have absolutely nothing to do with the case. And those are the questions that actually the interrogators find the most important. Like, what do you think should happen to the person who committed this crime? Do you think the person deserves a second chance? Now, if the person they're questioning says, yes, I think it should be something lenient, like it's a theft, they should pay back the money, or they should get probation, or yes, they deserve a second chance, the police interrogator decides that they're guilty. Therefore, every criminal defense lawyer in the world would fail a behavior description interview. While they're doing the behavior description interview, they then watch for body language. And they try to decide, based on body language, whether somebody's guilty or not. So, if the person is not looking them in the eye, but looking down, if they're exhibiting nervous behavior, you know, scratching, crossing their legs, then they're guilty. What's really interesting is that was the exact opposite. People who are interrogated, who are very much like look you in the eye, deny it, seem very straightforward, often are lying because they're so focused on telling their lie, part of what they're also focused on is communicating through their bodies whether or not they're telling. People who are telling the truth make you very nervous in a police interrogation situation. The most fun part of this is they have this whole thing about if your eyes go right or left. One way means you're telling the truth, and one way means you're not. It's all based on this thing called NLP, Neuro-Linguistic Programming. The NLP people are out there in the CLE world. So if you ever see a CLE based on NLP techniques, I just urge you to run it as far away as you can. Don't go to their seminar or year guided language of jurors. It's all bullshit. Your principles. But in it, when you go to this read school interrogation, it's really fun. You know, I go into this program at O'Hare Airport, you know, at Airport Hotel. I was usually late, which was good because I missed the whole introduction. I take my little place in the back, and what they did in this program was they showed us the whole first day or day and a half was spent until they got to the next steps. So they're having us watch these videos of asking these 17 questions, and then they're asking people in the room to judge if the person is guilty or not guilty. And I mean, it's ridiculous. Of course, every single person that they showed us the interview of was guilty except one. And the only person that they had the interview of who was innocent, which, by the way, half the people in the room I was guilty because of the way his eyes were shifting and his body language. The only innocent person in the whole tape was a police sergeant accused of stealing the evidence. That was it. So the deck's totally loaded. People are looking at this, going to the read technique. Like I said, the read school, if you have about $1,000 to drop, you can do this. They will. And I did have a really good time there learning all this stuff because I actually, you know, they didn't know I was a criminal defense lawyer, and I actually got to do like practice interrogation. And when the instructor found out who I was, I think it was really pissed all on me because I'm totally wasting this time. So I'm sitting there in the back, you know, in this room full of cops and private security people, and there's this guy next to me, and he's just going on and on and on the whole time I'm there, you know, in my ear. Lawyers are stupid. Prosecutors are stupid. Defense lawyers are more stupid. O.J. Simpson's lawyers were really stupid. You know, on and on. So, blah, blah, blah. Day 3, he turns to me and says, what do you do for a living? Better than MasterCard, I'm telling you. I just had too much fun. All right, so they showed us this little movie because their methodology reached Hollywood. They showed it in all seriousness, but I thought I would show it for fun.
I want you to look in the eye, Bob. Right here.
Turn the light.
Tell me, when did you find out Nick was investigating the fraud? First time that Nathan was conducting an investigation after I spoke with you after he was killed. You're lying. And I know you're lying. Oh, you know it. Wait. No, I'm not. I'm reading your eyes. I can't lie. Did you know what I was doing? A quick lesson in lying. See, this is what real cops do. We study liars. Example. Question about something visual, like your favorite color, and your eyes go up and to the left. Well, neurophysiology go in that direction because you're accessing the visual cortex. Therefore, you're telling the truth. And right, then you're accessing the creative center of the brain, and we know you full of shit. Now, let's try this again. What's your favorite television show? I'm not gonna tell you fucking game off there. Oh, why me, Bob? You're afraid we'll catch you on a lie? When did you find out Nathan was investigating the fraud? After I spoke with you.
Well, that is a fucking lie if I've ever seen you.
Blink my eyes, you scum. You don't have to blink me, Bob. It's your body language. It says you're lying. Hey, what do you expect, sir? Shut up, Frost. You know how this works. It's not just your eyes, Bob. It's everything. If you cough, sneeze, cross your legs, scratch your ass, they're all telltale signs. You can't cheat. You can spare me with those dead-ass eyes of yours all you want. Can't beat the system.
They love that. Anyways, moving beyond this, the thing I want to say about the behavior description interview is that your law enforcement department, if they're very strict adherents agree, they're going to do it. But some of them don't. I've seen it both ways in interrogations. But when they're done with that, they move into a bait question. The bait question, which they still consider part of the behavior description interview, goes like this. What would you say if I told you, and they name some in the case, generally which doesn't exist, okay? What would you say if I told you that your blood is being analyzed for DNA right now in the laboratory? What would you say if I had fingerprints? We have eyewitnesses who have identified you. This language, this conditional tense, what would you say if I told you, is very deliberate. Into the suppression hearing, and you say to them, did you lie to my client and say that you had evidence that didn't exist? They'll say, no, I never did that. I asked him hypothetical questions, probably. And that's what they taught us to do in the Reed seminar. Now, I have a few very short clips, and they're so short, I don't think I'm going to be able to run back and forth and turn the lights off each time. I apologize for this yellow color, because it's really ruining the video, but I have some, oh, you want to help with the lights? That'd be great. It's the other set. Wait till I hit the button though. But there's this case in Canada that I have some very short interrogation clips from, and you can find out more about this case on the CBC, Canadian Broadcasting Company website, including some transcripts of interrogation. But what happened was this young lady, 15-year-old girl, Darrell Exner, went to, Canada Burger King, got her burger, and never made it home. And she was raped and murdered, and these three guys were picked up and interrogated, and they all gave confessions. None of them had anything to do with her. About 4 months later, when the DNA came back, they were all let out of jail, the case was dismissed, and the true perpetrator was prosecuted. Here is an example from the Canadian case of a bait question.
You say to me, I said that we were told that somebody close to you that you killed Darrell Exner.
So that's the exact kind of language that they're going to use for the bait question. And this is going on in your police departments. They may or may not be saying, what would you say if I told you? But there's no question that they are implying to people that they have a huge amount of irrefutable evidence, because the point is they've got to make the person they're interrogating feel absolutely trapped, that they have the biggest possible case against them. And this is what people who research interrogation call maximization. In other words, this is part of what I call maximization. The case is maximized. You're trapped, it's hopeless, you can't get out of this. After that, they go into the 9 steps. And step 1, actually I'm going to run a video on the next slide. Step 1 is called direct positive confrontation. And what happens here is the interrogator at that particular point, and they have this thing, it's so scripted with the distance, they're supposed to stand 4 feet from the subject. So they establish dominance and make a very positive statement. You are the guilty person. We know that you committed this crime. I have a little video that I'm going to show. Now, one of the people in this Darrell Exner murder case was a juvenile. So this video is terrible because the face is all blotted out. But if you look in the upper left-hand corner, you can see the interrogator next to the subject.
Pass over files, top of the list. Just hold up online, get something to do with that then. Just hold up the wall.
You know, let me get this up.
There's no bill on my line. It's on the tubes for all that stuff. Okay, right?
Okay, so you see that he's sitting down now. He was standing up, he was 4 feet away. He was on the edge. I probably have another slide on this, what's called the social zone, which starts at 4 feet and ends at 12 feet. By the way, never get closer to 4 feet from a juror when you're talking to them, because you're moving from the social zone into the intimate zone. So that's what they do. And the next step is called theme development. In theme development, which is also part of minimization, maximization, there's a monologue by the interrogator. If you have cases where the cop says, this interrogation goes on forever, but they claim that your client never really denied the crime, if this is an unrecorded interrogation report, if you have that, it's probably because huge monologue, maybe there's been 1 or 2 denials, but they've done this huge monologue. It goes on and on and on. So what happens in this monologue? Oh, great, my phone's ringing. So anyways, okay, I'm bringing the cardinal rule.
Having a ring like that?
Yeah, and that you want to know who's calling me? Sean Maher. That's hysterical. Okay. Anyways, sorry, Sean, I can't talk to you right now. I'm putting my phone on silent. So, in any event, let me get back to where I'm at. No, now he's texting me. All right, you guys, I hope you don't mind. If it was been some. It's like, do you want to ride? No, dude, I'm here already. I saw you in the pool last night. Okay. I'm just going to take an example, and to have a common frame of reference and all, I'm going to use the Baker case. If the Baker case was happening now, this is how one of these things would go. The cop would, he would start out by saying, what would you say if I told you that we analyzed the blood where John Huster's died and we found your DNA? Then, after doing that, he would say, at some point, they might take a little break, and then he'd say, Larry Baker, I've gone over this case, and I'm positive that you killed John Huster. There's no doubt in my mind, and I want to talk to you about it. They'd sit down, close, moving from the social zone into the intimate zone now. Larry, I've looked at this case, and I want to tell you, this looks like a horrible, horrible crime. This guy, well-respected man, decent man, is in ground. And he was stabbed in the front and the back, in the head. And the DA is going to be reviewing this case later on today, and Larry Baker, anybody who looks at this case is going to say this is the worst, most intentional kind of murder. I mean, stabbing the guy this many times, late at night, in Grant Park, a defenseless baker. I mean, what kind of person would do this? The prosecutors and the judges, they're going to review this, and they're going to have to decide, Larry Baker, what kind of charges are going to be brought here. They're going to be looking at everything and what happened here. But Larry Baker, I have the feeling that you're not really a monster. I don't think you're really the kind of person who just went into that park and committed a cold-blooded murder like it was. And when I go and present this case to the prosecutor, I really need Larry Baker to tell me your side of the story. Because in my heart of hearts, after talking to you now for a while, and they'll do that because they've interviewed and taken family backgrounds, go in there. How's the prosecutor not to know that this wasn't the most cold-blooded murderer? We should really pay the price for what he's done. We can only know if they've heard your story. And Larry, I know you're a nice guy, and I've checked into your background, and I know you have some mental health problems. So something, tell me, Larry, what happened in that park? Something must have happened. This will go on and on and on. I'm just giving you the short version because we don't want to be here all day. Okay? So that's how it is. And then eventually we'll get to the theme they will develop depends on the crime, okay? You're a nice guy. You have mental health problems, okay? That man must have said something or done something to you to cause you to stab. That's the mental health thing. Maybe it's a gang case, okay? Maybe it's, look, you're not a cold-blooded murderer. It must have been self-defense. It must have been an accident. It must have been, that you didn't really coercion. I mean, all these kinds of things. This is how you get these statements, you guys. Where somebody's been shot 17 times and they say it's self-defense. This is how you get these statements. They're police-induced. So, I have a video of theme development from this case.
If the girl did something to you that was so bad, she made you lose your temper, and then this thing might shit, you didn't plan it, that's what happened. And we can understand that, because that makes sense. It could have been an accident. But it was really hard to catch.
Those words that they say, we can understand this because this makes sense. Oh wait, I didn't mean to do that yet. Okay. We can understand this because this makes sense. That's the kind of stuff they do because they know they can't make these overt promises. Okay? When they cross the line, if you have it on tape and it gets the press, is usually when they say, you know, they're going to throw the book at you. You know, you're looking at life, but if you do this, we can get you this amount of years. And you know, I actually had that on tape. I mean, the police are getting better in Milwaukee as time goes on, but we've had a lot of weird stuff on the tape in the beginning, and we were getting confessions suppressed, like right and left, 6 months after reported interrogation happened. I'll talk about that a little bit more later. But this theme can go on and on and on. There's a case from Minnesota where I read the transcript of an interrogation. They were one of the first places to have recorded interrogation. And the monologue by the interrogator took up the first 55 pages of the transcript. And a lot of the things they build into this theme are personal stories in their type of theme development. And the stories frequently center on how they, the cop, grew up in a poor neighborhood, in a humble background, had some brush with the law, learned their lesson, and went on to become the police officer that they are. Or how their neighbor killed somebody, but told the truth. It always has to do with they told the truth, and they only got, you know, a few years, and now they're out, they're married, they're working, blah, blah, blah. So the stories will be about themselves or a case they worked on. It's extremely common. And what usually happens as you start this interrogation, just like we saw with that kid, is there's denials. So their view on handling denials is that you have to cut them off and return to the theme. And I have a little video of the denials here if you want to do the lights for me again, that's great.
Okay, I know what the relatives looks like, okay? But yet, I bullshit. No, listen, no. I'm telling you something. All right? I don't appreciate you like it. All right? I'll tell you what. I get 2 separate statements from 2 different people at 2 different times. Both of them say that you were with them when they walked throughout home.
Okay, the 2 separate people at 2 separate times happen to be the 2 co-actors who gave false confessions, all right? So, cut them off, dominate, return to the theme. That's what they want to do in this step of the interrogation. Here's another.
See, if you stick to this story, you're going to get convicted. There's no doubt in my mind. You never should get him going to court and say this is exactly what happened.
Okay, step 4 is what's called handling objections. Handling objections is not the same thing. An objection is not a denial. An objection is when the person says something about themselves personally and how they wouldn't do it. So if Larry Baker says, for example, you know, I wouldn't kill somebody. I'm a very peaceful religious person. I go to church every week. It's against my, you know, religious viewpoint. The cop would say, now Larry, I know you're a religious guy, and I know you believe in God, and I know that's why you didn't do this intentionally. That's why this was an accident. They'll take that and they'll loop it in and incorporate it into the theme. Steps 5 and 6, by the way, they call them steps. These don't necessarily all happen in chronological order except for the confrontations, and they move into theme developing. But from there on, they all kind of get mishmashed together, all right? This is about usually when a person is being interrogated after a while as things go on, they're not being listened to, they're not being heard, they start to withdraw. So what the police are doing then is they're moving closer and closer into the intimate zone, and I do have a video from a different interrogation where I'll show you this. And they're going to like really keep the person with them. So as they are doing this, they're going to get much closer. That video's not coming next. And they're going to get really close. Hand on the shoulder. Come on. You know, it's all going to be done real empathetically though. It's not threatening. Not if they're following the Reed technique. Step 7, and I will have a video on that after the next slide, is what's called the alternative question. When the interrogation has progressed to a point where they feel the person is ready to confess, they're going to pose 2 choices to them. Both are guilty, but one is kind of a lesser. That's why this is like a de facto plea bargain. And it would go, Larry, tell me, was this a cold-blooded, intentional murder? Or did you just snap because of something John Hussers did to you? Okay? That's how that's going to go in the interrogation process. Now, they always get what they want, and then they return to the theme. So here's an example, again from the Canadian case. It's very short.
Did you guys, I swear, did you guys watch what happened? Did
Okay. What do you think the kid said? The Juvie said he just watched. That's what's in the transcripts. Then they're going to, when they get this person who says, I just watched, or it was just an accident, this is not a confession. This is an admission. And it's very important to note what the difference is, because they have to then get the confession. It hasn't happened yet. Well, what they have to do to get the confession is do what people who study this call getting the post-admission narrative. Now, the Reed people will admit that you can get a false admission using the Reed technique. They claim that you cannot get a false confession if you use the Reed technique, because what they claim is the interrogator during this particular phase is supposed to just ask open-ended questions, not feed any information to the subject, not judge what they're saying, but simply go, they say that you should go from the general to the specific. What happens in false confession cases is that either the details given are totally wrong by the person, or the police drop enough information into the interrogation that the person knows what to say. There's other reasons people could give false confessions. Their friend may have committed the crime. I mean, they may have details from other places besides the cop, such as they were there but a witness, not a perpetrator. A friend of theirs committed the crime. They read about it in the newspaper. I mean, all of these are possibilities to how you can get a false confession. The myth that exists is that false confessions are totally devoid of details. They're like Larry Baker confessions, which have absolutely no details in it. That's not true. They are richly detailed. That's what the studies show. So what they want to do is they're taking this statement, if they say that they've got to get the details that only the real perpetrator would know and the police should not disclose that to them. They also instruct their people to not be writing during this particular time, because having a pen in your hand reminds the suspect of the legal significance of what they're doing. So just take the story, go from general to the specific, and then get a written confession, which the interrogator should write out in order to maintain control. And in the written confession, they will always cross out errors so that when they read it back to the person, they'll have them initial it. That's done deliberately. And write a letter of apology to the victim. This is what I used to get before we started recording interrogations in Wisconsin. They no longer write them out anymore where I practice. Some places still do.
The thing about the cross-out error, I've seen that before. I mean, but I don't know, I want to make sure I'm thinking the same thing that you're talking about. They've written out the confession for the person, and then they cross stuff out to show like they're really thinking about certain details and maybe got something mistaken.
Spelling errors. It could be detailed, but usually what they do, as the interrogator is taking it down, they will make deliberate errors of spelling, grammar, or location, or people's names. Maybe they'll put the wrong name in, maybe they'll put the wrong street in, and then as they're writing it out, they'll cross it out and put the real thing in. Okay? Then when they read the confession back to the person, they'll notice the mistake and they'll say, can you just initial that right there to show I've gone over it with you? They think that that helps prevent viable recantation when the case goes to court. I had a case once. A lot of the cases I do, because I only do homicide cases now, so I have very high-end interrogations. I've got a lot of cases where my clients are interrogated 4, 5, 6 times before they get a confession out of them. So I had one of these cases once, and the suppression motion went on literally for a week. This was in the pre-recorded time when we had to reconstruct the whole thing, but I looked at each one of these statements, and what I noticed was the first 4 of them were all denials. There were no cross-outs in the written statements at all. None. Then in the 5th and 6th, there were tons of cross-outs. So I was cross-examining the cop about it and saying, you're taught this. You know, this is one of the things you're taught to do. You're taught to make deliberate mistakes. And the guy says on the stand, no, I just make mistakes. All right? So I look at this thing. He's got stuff written correctly and crossed out, I'm talking about spelling errors here, and then written incorrectly. And has the client decided that. I mean, it's such bullshit, you know? But this is part of it. This is in the Reed book. So, to sum up, I think that 9 equals 3. The first part, we have a really strong case against you, it's hopeless, you can't get out of this. And that's the presentation of bait evidence, false evidence, etc., etc. Number two, only confessing is going to help you. You've got to give a confession in order to minimize what's going on here. So we have maximization, minimization, part three, get the admission, construct the post-admission narrative. They have a lot of emphasis read on room, and as you can see in these slides, there is no barrier between the interrogator and the subject that they are interrogating. They believe in moving that, and oh wait, I got a video here. This is hysterical. The next couple of videos are from a case being another kind of a false confession case, Raymond Woods. I say kind of because I don't think he really gave the true confession, but he did spend a year in jail. Raymond Woods was a guy in Maine. He was like one of these guys, like he and his girlfriend were constantly drinking and fighting each other, so there were a lot of DV calls to the household. Well, one of the days, they did a lot of drinking, a lot of arguing, he left, and he was pissed off, and he went and actually slapped that kid where he worked. She was found dead, a victim of a hit and run. And the police decided it must be him, of course, because of all these domestic arguments that occurred all the time. So they arrested him, and they kind of got him to confess. He did one of these confessions that they call the coerced internalized, in other words, where the person really comes to believe they might be guilty. By the way, that belief generally ends when they leave the interrogation. People who, there is a methodology where they say to people, you know, you had a blackout, and that's what they did in this case. You know, you're drinking, you had an alcohol blackout, must have gone that way. And the person had been drinking, is not really sure. Well, this guy was totally innocent. Some of the stuff they told him, like her blood was on your car when the defense lawyer sent it to the forensic lab, it was deer blood. That the part of the car that was found at the accident scene belonged to a different car, it didn't match his car, and the judge suppressed the statement. But look at this, how they got into the room layout thing here. This is hysterical.
Well, just gonna move this out of the way, this thing's too damn big. I just move this thing. When you check me out for me,
Not right. And so, you know, sometimes if they still have a table, this is what'll happen. This dot right here would be your client. This would be the cop. They may have the other person stand in the corner. And sometimes, you know, the person will say, look, I don't really want to talk to you anymore. And they'll just move right over by the door. But just because of the physical thing, it just intimidates people. I talked to someone who was a former cop who's now a defense investigator who was retrained. And he would tell me how they would do this, especially when the person wasn't in custody. When they had these people who walked in voluntarily and they're like, I had it, I want to go. And just standing there by the door would change the dynamics and the person would change their mind. So I think I've already commented on this, that they start the interrogation at the edge of the social zone, move into the personal zone, move into the intimate zone, close in as the interrogation proceeds. And I believe it's the next slide. We took the video from Raymond Woods and we sped it up. I hope it's the next one. Oh no, I didn't have it in here. Oh, I'm so sorry, you guys, but it's really fun because they took their chairs and they keep moving in and in and in. We sped up the film like 10 times. You know, we turned a few minutes into a few seconds, and it's just a freaking riot. Okay, so that's the end of this part of the presentation that just deals with how they interrogate suspects. Now what I'm going to move into is what you do to prepare the case. So this is the next section, what I'm going to talk about. And then the last section I'm going to talk about is I'm going to talk about the cross-examination that you're going to do in both the motion hearings and during the trial. Okay, first of all, I know this sounds ridiculous. Like I'm telling you, this is the same thing as reading the discovery. But for those of you who have recorded interrogations and long ones, you probably know what a pain in the butt this is. Okay, I mean, I have cases where I have to listen to hours and hours and hours of interrogation, and it gets very boring sometimes. So, and weird stuff is on these tapes, you know, as they have these conversations about, I mean, I've heard some really weird things. Sometimes we start to regret, you know, like the part where my client said he had a secret fantasy that he wanted to eat people, he wanted to see what it was like, he wanted to try cannibalism. There's this whole discussion. There's stuff that you got to make sure in your motion in limine, if the confession's coming in, that gets out of there. I'm telling you, there's all kinds of weird stuff. But anyways, you have to listen to the tape, the whole tape. And there are lawyers not doing this, which really disturbs me. And if you're like it is in Wisconsin, not only are my clients on tape, but a hell of a lot of the witnesses are in custody and they're on tape too, which is the best impeachment for these trials. I mean, it's amazing what you can do with the stuff. And you have to play the tape for your client. They have to listen to it, and you have to get it transcribed. And I want to talk about transcription first. In Minnesota, the Supreme Court has ordered the police departments to transcribe these things. But, I mean, we're really suffering in our office because we have a secretary who does nothing now but transcribes tapes. And in terms of your practice, the important thing is you need to get enough lead time. You know, anyone who's practicing seat-of-the-pants law, you know, the public defender model. You guys know, have you ever heard the public defender model? No? It's not really the public defender model. Always ready, never prepared. Nobody's ever heard that before? It's bullshit anyways, we all know it's not true. But the point being, you have to really prepare for these hearings. And you can't go into court and do a suppression hearing and not have a transcript. So I don't know what the deal is where you practice, but where we practice, you know, although the burden may be on the DAs, their transcripts are terrible. It takes about 8 hours of secretarial time to accurately transcribe 1 hour of tape recorded material. All right? And then, so we have the secretaries do it, then I re-listen to it and look for errors, then I have to hand it back, and she has to go check through all my errors and see the errors I pointed out and see if she agrees. And then she certifies the transcript. You need it to be certified to get it into court without having to call in the transcriptionist, secretary, whatever, into court. Now, somebody here talked to me about a problem in their jurisdiction of not being able to use a transcript because it hadn't been done by a certified court reporter. Those rules vary from place to place. We don't have to have a certified court reporter to use a transcript in court if it's not a transcript of an official court proceeding, you know, and this isn't, obviously. So what are you going to do? You want to examine the statement for contamination. And this is one of the most important things. If you have a recorded interrogation, it's obviously way easier to do this. Because we're working with two different issues here, right? Suppression is about coercion. It's all about coercion. The judge isn't supposed to consider whether the confession is truthful or not. Trying a false confession case is about coercion plus contamination. Because the jury can think it's coerced, the police were bad, they did the wrong thing. But if they think the confession is true, they don't care. You lose. So it doesn't really matter. If they think it's coerced and untrue, then you can win the case. So what you want to do is, how can a confession be untrue? How can it be false? It has to be contaminated. And so if you have these confessions, you need to analyze them line by line, whether it's on tape or written, and you have to know and account for every single thing in that confession, okay? What was already known to the police and to your client? What is true and what is untrue, okay? So, and if it's not true, if it's contaminated, what is the source of the contamination? Is it the police, because they do say things that contaminate confessions? Is it in the media? Does your client know other witnesses? Was he there but didn't commit the crime? Did a friend of his tell? You've got to figure out every single thing in the confession where it came from, or you cannot win a false confession trial. What is incorrect in the confession and what is correct? Because generally speaking, all confessions have a lot of erroneous information. They're very richly detailed, but they're usually wrong. They don't necessarily match the physical facts. And as you examine the confession, find out, you know, is it written in police talk? Now this is going to be more for your written, unrecorded statements. Did they use police-like language? Or is it the kind of language your clients uses? Is it vague? Is it in the conditional tense? In that Raymond Woods interrogation, when they are eventually getting him to confess, and I don't really call it confession, they convince him he had a blackout and they're trying to talk to him because he tells them, you know, when he's saying he's innocent, that he left the house and he went to the right. Well, the accident was to the left, coming out of, you know, farther down the left. And they get him to believe he had a blackout, and he says, well, I would have had to have gone that way if I hit her. I guess I would have had to have done this. I would have had to have done that. And he never says I did it because he doesn't remember. And there's a real famous false confession case some of you might have heard of, the Michael Crow case from California, where this juvenile was talked into, interrogated repeatedly until he confessed to killing his sister. Eventually they got the real perpetrator. It's pretty well known because there was a documentary made out of it that was shown on HBO and stuff, so you can Google it. But Michael Crow was one of these people who, during the interrogation, they convinced him that there was two Michaels, a good Michael and a bad Michael. And he just couldn't remember what bad Michael did, and that he had blocked this from his memory because it was so horrible. So you want to look for that. You were looking for if it's inconsistent with the other evidence in the case. Generally speaking, false confessions, because the person wasn't there and didn't do it, they're going to have erroneous details. And then finally, you want to look at what wasn't followed up on. Because the Reed people say two things. They say there should be dependent and independent evidence. Is during the interrogation process itself, they should be getting some information from the subject that nobody but the true perpetrator would know, that is not somehow leaked out during the confession. Then, what the police interrogator is to do is to take this information that they got in the interrogation and go out and verify it. So when I went to the Reed School, they showed us a classically good interrogation. This guy was accused of killing his next door neighbor, okay? They showed us the interview, they showed us the interrogation. He confessed to killing her. He gave details like that matched the blood trail that only the real perpetrator would know. They didn't let the facts out during the interrogation. And then he told them where the knife was that he had used to stab the woman. They went, based on what he said, got a search warrant, recovered the knife from his home, sent it to a lab, and got corresponding DNA evidence. That is like a perfect prosecution, perfect interrogation type of case. That's how they're supposed to do it. What's really great is they have articles about this stuff on that investigators tip. You can keep going back and find it. It can make very good cross-examination fodder if you have a properly trained police officer. I'll talk about that a little bit later. So you want to study interrogation methods, and there's a lot of different ways to do it besides reading the Reed book. First and foremost, I think you need to take a look at the training materials that are used by law enforcement in your particular jurisdiction and by the cop in your case. So I don't do this as much anymore as I used to in the recorded time of interrogation, because I can usually work with what's on the recording. But especially when I had unrecorded interrogation, I couldn't tell exactly what they were doing during a motion to suppress. I would subpoena the training materials, and the subpoena would be very specific. I would ask for this particular officer all the training they received prior to the date of the interrogation. And what I found in the Milwaukee Police Department is they're sending people to the Reed School who then come back and train their officers, and their training materials are a derivative of Reed. Okay? Another really good way to do this is to subpoena retired police officers. Police departments are generally revolving doors of very unhappy people. You know, there are people who do not love their jobs, and generally speaking, want to go out and make more money when they're done. And it's really great. Bring them into your office, hire them as consultants, talk to them about what happened, and talk to other lawyers where you practice. You know, I've compared notes. I've sent out letters to everybody on our homicide list, compared notes. You know, have you had this detective? What did he do? And again, before we had recordation, this was extremely important to me to do this. Now that we have recordation, it's not that important. Your client interview is really crucial, and I don't know if it's in the materials here from the college, but you can email me or you can Google me with Stephen Drizin, D-R-I-Z-I-N. He's the head of the Center for Wrongful Convictions at Northwestern University, and one of the major people kind of in the false confession field. You know, there's a bunch of people who you probably, if you really look at this field, you'll hear their names like Richard Leo, Richard Offshee, Saul Casson, Stephen Drizin. He's published a lot. He studies false confessions. He has a blog. He and I wrote a client interview form for people who have a confession case, particularly for people who have unrecorded confession cases, but you can use the form for anything. It's about 5 or 6 pages. of things that we suggest that you interview your client about. Very in-depth. So if you Google Stephen Drizzen and I know it comes up as a PDF from some training materials for a program, or you can email me and get it. But in any event, these are some of the important things. Whether your confession is recorded or unrecorded, you really need a very thorough psychosocial history. Because when you do your motion hearing, you've got to know what the particular vulnerabilities are of your client. Because once you have established some level of police coercion, the court is then to weigh that against the vulnerability of your client. So you want to take a very thorough psychosocial history. You want to really learn about the pre-interrogation events, and you want to totally reconstruct the interrogation. So if you don't have a tape, this is painstaking work, you guys, and clients are very poor historians, generally speaking. So you need to interview them as soon as you can after you get the case, and we're talking about a substantial period of time for interviewing. But now that you understand and know the read technique and how it operates, you'll be in a position to ask them questions that you wouldn't have known to ask them before. Like, who would have known, should you ask your client, did the police ever say something like, what would you say if I told you? I mean, you wouldn't probably know to ask that unless you're trained in the read technique or some of the other things they do. So you're going to interview your client armed with your knowledge of how police actually interrogate people. And now that you can do that, you're going to be able to do a much better client interview. Now, Richard Offshee recommends that you have your client reconstruct a timeline. This other, and Matt Kavanaugh, who's a clinical psychologist who I've used in these cases, says that, say to your client, pretend we're making a movie and have them do the signs, have them write a story. That's all great. These methods will help you do this, but generally speaking, when I have asked my clients to write a timeline, write a story, and then I come back to interview them, their stories suck. I mean, there's just such huge gaps of what happened. So you really have to conduct the interview. You cannot rely on your client doing a written reconstruction for you, okay? So the other thing to really understand and know about interrogation is the polygraph and the voice stress analyzer. These are not tools for finding out the truth in the hands of police interrogators. I don't know if they're tools for finding out the truth in anybody's hands. The polygraph has some degree of reliability, maybe 90%, so there's still a big margin of error. The VSA is a flip of a coin. But a lot of departments are using these voice stress analyzers because they are less expensive. The actual cost of buying the equipment is about the same as the polygraph, but the training is much, much cheaper. The upkeep is much, much cheaper. And so they'll give these people these tests for the explicit purpose of telling them they failed them and getting a confession out of them. That's what the purpose is of these so-called lie detection tests in the interrogation process. You want to find out, a lot of times, the results from these tests do not come with your discovery because your state may have statutes that prohibit the disclosure of a polygraph result without the consent of the person who took it. Now, so it's separately in discovery. There are pre-polygraph forms that you don't usually come in the regular discovery, and these can become very helpful to you when you do your motion to suppress. So you want to find out all about this. And then there's the whole issue of experts. If you have a false confession case that's going to go to trial, you generally need to have two experts. One of them is a clinical psychologist. The clinical psychologist is going to interview your client and test them. And there are specific tests that can be used for false confession cases. The IQ test is obvious if you have a client who's got some cognitive issues, because there is a much greater rate of false confessions with juveniles, people who have cognitive issues, people with mental health problems, people who are highly suggestible, and there are psychological tests for these things. However, it's important to keep in mind that in the study of false confessions that have been done, over half of the people who give false confessions are none of the above. So perfectly normal, intelligent people are giving false confessions. Nobody really knows what the false confession rate is in the United States. It's impossible to measure. We'll do a statistic that say it may run as 1% to 3 or 4 or even 5% of all confessions, but nobody really knows. What we do know is the rate of false confessions do rise with these more vulnerable populations, and they also really go up for crime. Almost all of the false confession cases are in homicides, sexual assaults, and arsons. But there are these other tests. There's the Grisso-Miranda comprehension test. Has anybody ever heard of that? Okay? And the Good-Johnson suggests these are tests that are specific to the issue of interrogation. The Grisso-Miranda comprehension test. Thomas Grisso is a psychologist, I think he's in Boston, if I'm not mistaken. Very famous for his work with juveniles. He has developed a test. So if you have a juvenile client or a cognitively dysfunctional client, this is a really good test to give them. What the test does is it measures your client's ability. What the heck is that? Anyways, it measures your client's ability to understand and waive their Miranda rights. The test consists of two parts. Part of it's verbal. You know, the Miranda warnings have different reading levels. You have the right to remain silent is at 2nd grade, but the 5th prong can be as high as the 12th grade reading level for some people. The second part is pictorial. They'll show them pictures of an interrogation room with the police and people in there, and they'll have them explain what's going on. The pictorial part is weighed more heavily. But that test, a psychologist can give that client a test and basically give you an opinion in court and testify in a motion hearing whether or not your client understood and therefore freely and knowingly, voluntarily waived their Miranda rights. That has become very important, this issue of understanding Miranda in litigation now, because Miranda is almost dead after this term in the U.S. Supreme Court. I'm just not remembering the name of the case right this second. Huh?
Howell.
No, it's not Powell.
Padilla.
Huh?
Padilla?
No, Padilla's about immigration.
Isn't there
It'll probably come to me as we're talking. I will talk about it when we get to it later. The Good-Johnson suggestibility scale was developed by Gisli Good-Johnson, who was a leading researcher and expert in the area of false confessions from Great Britain. He's one of the top people in the country, in the world. And it was really exciting because in 2006, for the very first time ever, there was a conference organized by the American Psychological Association and UTEP, you know, the University of Texas at El Paso, that brought together all of the people in the world who are working on the subject. And I mean in the world. There was like, I met a psychologist from Japan there. Gisli Good-Johnson was there. But they have developed, he's developed this test where what the test specifically measures is if you give people questions and they give you an answer and you tell them, no, that's not right, or you suggest that somebody else said it wasn't right, will they change their answers? And they come up with these two numbers, yield and shift. I can't really explain it right now.
Oh,
What the hell?
I have to do this because I don't have a voice left, okay? There was a real problem last night of saying, screaming at the top of my lungs saying, get your ass in the pool. All right, my name is John Lentine. This is Howard Coon. I apologize that my probably best friend in the world, another teacher at College of St. Denis and I, we were in Oregon to do this creative motion practice lecture. So Oregon is, of course, you know, the home of the Pac-10, which is the greatest football conference in the world. At least they think so. Oregon has mascots such as those things. And as I told them, you know, what would I know about football coming from Alabama? You know, what the hell do we know about football? You know, and if you're from Florida, I'm sorry, but no, I hate your asses, so, you know. Anyway, but if you're from Georgia, it's even worse.
Yeah, but let's go on.
So, St. Denis and I started putting this together about 5 or 6 years ago, and the idea was, you know, how can we be more of a pain in the ass to prosecutors, and how do we be more, you know, how do we get more effective? Because, you know, the issue, you know, half of the issue is
That's 5 years, probably like, you know,
We didn't do it.
I mixed in the pool, I'm like, I left at 12.
Yeah, it's
here than he was the,
Yeah.
this is so dumb.
It seems like they got it turned off.
Yeah.
Very interesting.
I follow that.
Yeah, you're the guy who.
I'm well behind my slips. They keep on putting them out. You can't read everything. Well,
Oh, yeah, the unambiguous language. Yeah.
Well, I think that that has an issue. I think you should talk to a toxicologist or a psychologist who's also an expert in drugs, an interrogator, which is under the influence of something. That does play into the vulnerability issue.
She has all these really her own address during the time that she remembers these. So I was going to that. She remembered the name of the boyfriend, he like her was very erratic.
Yeah.
Sort of amounts to confession at the end of the day.
Right. So I want to maybe, is there any short how much was
Yeah,
it?
it'd be like a
At the
whole
time
day.
during blood samples taken?
She was, ordinarily they would take her quick, but she was high enough, they would take her to the hospital and be on beforehand, and they did that.
Right here.
Well, but maybe some of the experts who are Yeah.
Or maybe just kind of, you know, see what I'm interested in, what you're doing is you're having a twin like those, and you're also having somebody else. Right now, I have one at a time.
Maybe a toxicologist or somebody, a psychologist who's a real expert in those, really talk about the effects of somebody's ability, time, and their ability to resist suggestibility. Maybe a special, more specialized expert. That's my
All right.
opinion on the topic.
Like, I don't think I did that.
I mean, I looked for some like cans of bubble.
Okay, I'm gonna give it like another minute or so. Let people straggle in here and then we're gonna get going here. Do I have this? Yeah, it'll come up in the but honestly, I don't it's either on the written materials here or you can email me. Or I'll write you in the room at that time. Just send me an email and I'll send you the it's not on that disc. Okay. Yeah, it's way more valuable for a stay-at-home thinking.
Okay, I got
Yeah, okay. All right, I think we're kind of all back here, it looks like, or just about all back here, so. All right, so I wanted to say something about the Grisso and the Good Johnson, because I've really done a lot of motion litigation, and I have had a lot of confessions suppressed over the course of my career. That means like half a dozen. Right? No, I mean, but, you know, I was once in a room at an ACL meeting, and they asked everyone to raise their hand who's ever had a confession suppressed. So, you know, a bunch of hands went up. How many people have ever had 2 confessions suppressed? Me and one other person. How many people at that point in my career? It was only 3. 3. I was the only person who raised my hand. Gary checks me and says, put your hand down, Deja. You know, this is all you do. This is not fair. But really, you don't get a lot of these. Well, you know, my number's now gone up to 6 because since we have recorded interrogation, we've had a lot more to work with. But, you know, what I want to say, the important thing I want to say is that in all of these suppressions I've ever done, I've only had one client where I could have testimony on the Grisso. And I've had a lot of people tested on it. One client. And I've never had a client who Oh, yeah, I had one, and I got the confession suppressed on Miranda grounds, so I didn't have to put the expert on. One, who I was going to do something on, the Good Johnson, it wasn't even, it was also a, I can't remember what it's called, but there's another Good Johnson test too, but I've only once really had a psychologist who could testify to these things. So don't be discouraged if you get these tests done on your clients and they don't give you the good results, because that doesn't mean you have a bad case for suppression just because the psych eval stuff doesn't come in good. Because quite frankly, the main thing that induces false confessions, although we have these vulnerable populations who are more susceptible to it, the main creator of it is police interrogation. And that's why the other expert that you want to try to hire is a research psychologist or social scientist who has researched interrogations and confessions and can talk about how police interrogation methods can induce a false confession. The problem with this kind of expert is that it's running about 50-50 about whether you can get their testimony in. There's really bad opinion from New York recently that does not allow it. There's a really good opinion from the Seventh Circuit. So it's real varied around the country. If you want to collect these opinions, there's law review articles written about them. That's the fastest way to research it, probably. So you're going to have to really fight to try to get this kind of research in, and you have to show that it's relevant to your case. So you're going to have to probably demonstrate that these techniques were used before it's going to be relevant for an expert to come in and talk about how these techniques can coerce a confession. What the researchers have shown is the average police interrogation, in other words, 90% of all police interrogations last 2 hours or less, or maybe it's 1 hour or less. And I find this to be true. I mean, once we went to record an interrogation, we have a lot of 30-minute tapes coming in our cases, in our office. There's a lot of 10-minute tapes, you know? You're not probably going to win coercion on those, because it doesn't exist. But the average false confession is 6 hours or more of interrogation, and it really goes up. The higher the number of amount of interrogation time, the higher the probability of a false confession. I think it's great to investigate the interrogators in preparation for your motion hearing. Now, we have CCAF in Wisconsin. That means everybody's court records about everything is online. I don't know, did you shut the air conditioning off in the room too?
I just turned the volume down.
Oh, okay. Because it's like warm in here to me, but whatever. Misconduct, discipline, you should subpoena that kind of stuff. In one of my cases, this is a really long time ago. This is one of the first confession cases I ever litigated back in the 90s. This cop, I compared notes in this case with his interrogation techniques. And it was really interesting because I wrote to these other lawyers and we found out he had done the exact same thing with their clients, which was to bring a file into the room and tell the story of the confession that of 3 defendants confessed and testified. They only got 10 years. One person confessed but didn't testify. They got 20 years. The defendant who didn't confess and had a jury trial got convicted and went away for life. And he's doing this to try to get my client to confess and blah, 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 blah. But one of the things I found with this cop is I just threw his name into Lexis. He had a civil suit going in federal court because he had killed somebody when he was off duty. And the judge in that case had done an in-camera inspection of his police personnel file. So he had misconduct that I couldn't reach. That was enough because, you know, if you're going to try to get misconduct stuff and it's privilege, you've got to do a Pennsylvania versus Ritchie motion, whatever it's called, where you guys practice, and you have to have some showing that there's something there. So researching them using Google, CCAP, Lexis. You know, Lexis is very good for researching people too. Have you guys ever used that feature? You know, there's a people search thing on Lexis where you can find people's criminal records all over the country. Very helpful. A lot of lawyers don't know how to use it. They only use the legal research part. But you want to take a look, you know, transcripts, civil suits, all this stuff. You want to find out as much as you can about these people. Now, like any other case, you're going to go view the crime scene. The crime scene in a false confession case is the interrogation room. So you should go inspect and photograph the interrogation rooms where you practice. The police department might not want to let you in, so you might need to get a court order. Most places have a motion to inspect land. They're in the civil statutes generally, not the criminal statutes. But if something is non-existent in the criminal statute, you can bring a motion in or land. We had to do that, and then the city attorney called the police department and said, "This is a loser, I don't want to go to court, set up a date." So we called the police department, they're all flipped out. You know, the defense lawyer and the defense investigator are coming in to measure and photograph the interrogation rooms, and they thought we were going to doctor the evidence. So we went through the interrogation rooms. So they sent their own guy to photograph and measure the interrogation rooms. So we would measure, they would measure. We would take a picture, they would take a picture. You know what? Their pictures came out better than ours. So I used their pictures. They were like flipping out. You know, I mean, it's the most ridiculous thing, but it was hysterical. So there's fun things there. Okay, moving into the whole issue of pretrial motions. When you do a pretrial motion, you have to have some kind of a strategy about what's going on. Are you doing this motion because you're going to win it, or are you using it more for discovery? Now, some of you have depositions where you practice law. We don't. My motion hearing is my only opportunity for a deposition. You need to decide if the client should testify. A lot of people don't want to put their clients on the stand in these motions to suppress. I advise that you do it, if you can, unless there's some horrible reason that you can't put the client on. I think it's good. How is the court to know that they felt coerced during the interrogation process? By osmosis? Through the lawyer? I have won a lot of suppression motions, and I'm convinced it's because the person who was interrogated got on the stand and testified about what happened. I mean, I'm positive of it, that I wouldn't have won these without them. The state can't use it in their case in chief, and if you prepare the client properly, and you should prepare them just like you would for a trial for these motion hearings. You're going to get a good dry run and see what the prosecutor can do with your client. The other thing about motion hearings that I recommend, if you have a real serious one where you think you can win, you're not just conducting a discovery, I would do an opening statement before the motion hearing starts. Now, it's not going to be the kind of opening we taught you guys to do here. It's a 2-minute opening defining what the issues are that the court's going to focus on. But a lot of judges really appreciate that and think it's a really good idea because you're going to focus exactly what the issues are. You know who gives openings and motions all the time? Barry Scheck. Okay? So if he can do it, we can do it. But I think it's really a good idea. And when I say let the court know it's extraordinary, every case that goes to trial usually has a state hearing on the admissibility of the statement. These things are a dime a dozen for judges. But you want the judge to know, hey, my case is special. You know, I'm serious about this. And the way you do that is by never filing a boilerplate motion. File a motion with very specific facts about what happened and what the legal issues are. So, I'm totally against boilerplate motions, boilerplate work. No judge wants to take that very seriously, okay? Now we have this little problem. Is this really necessary, Your Honor? I'm a detective. The police credibility problem. This problem has kind of gone out the window with recorded interrogations because I have now done motion hearings where we submit the CD and the transcript to the judge in advance. She listens to it. I've had the judge come out on the bench after doing that, get on the bench and say, I'm prepared to rule. And the prosecutor went into an apoplectic fit and said, Judge, we have to make a record. And I'm like, okay, they never say that if the defense is going to lose, But we're basically done here. And, but in unrecorded confession cases, you have this problem with them believing the police about everything, and how you cross-examine them in the motion hearing is going to have a lot to do. So all of the issues need to be raised, and I want to talk about them. Why do I raise unlawful arrest, even if I think the arrest is legal? I mean, obviously, if there's an illegal arrest and the confession's not attenuated, you can get it suppressed. But what I really like about raising it, because usually there is probable cause for the arrest, is it makes the prosecutor litigate the lawfulness of the arrest. So every weakness in the case before the confession was taken can be explored. Why is this important? It's because judges are human beings. I know it's really hard to see them that way once they put the black robe on, but they are. I know. I was until June 11th married to one. So in any event, judges are human beings, and if they are honest human beings and thoughtful human beings and want to follow the law, there's still the human part of them that says this is a bad crime, and they want a conviction, Because who really does want to let a real murderer or somebody who's a kitty diddler back on the street? Nobody. However, if they're a thoughtful and good human being, they do not want to see somebody go to trial when it's a false confession. They don't want to subject an innocent person to a trial. They want them to go free, okay? So, since we can't really litigate the issue of whether the confession is true or false in the motion hearing, since that's not really per se relevant, you may have a subtext that the confession is false if you can also show the judge how weak the case was. So when you go through the probable cause, that gives you a chance to show that the description of the perpetrator was a person who's 6'2" and your client's 5'8", that they don't have any DNA evidence, that the witness they talked to who identified your client was drunk during the time of the crime. I mean, whatever it is, okay? You can really show the weaknesses of the case and how important that confession is, and it gives you a good dry run for the trial on that particular stuff. Now, some people think, well, when my client testifies, I should have him say he gave a false confession. And that, bye-bye, I'll talk to you soon. Bye, have a good week, everyone.
Bye.
So, I think it could backfire on you. I once took over a case that another lawyer had done the suppression motions on. I hadn't done it, okay? It was a really hideous murder where this guy had been, after killing him by injecting bleach and battery acid into him, they then set the body on fire. They decided it could still be discovered. They recovered the body, cut the hands and the head off, took the body over the state line, dumped it again, set it on fire again. By the way, I looked at the autopsy pictures, you guys, I couldn't eat meat for a day. Just a day. I have a strong stomach. Because it really looked like come off a barbecue pit, and it was awful. But it didn't even look real. It looked like a Hollywood thing, But in any event, this other lawyer had litigated this motion hearing. Eventually, my client took a deal where he testified against the co-actor. Can you believe it? My guy, he only got 10 years on this case. I mean, it was amazing, the deal that got cut. But, I'm scouring this past motion hearing because, of course, the client was always telling you, of course, we were going to go with false confession defense until I cut this incredible deal for this guy. Then I'm like, oh my God, what if he says it was a false confession under oath in the previous testimony? We're sunk, they could bring a perjury against him or something, potentially. So, I scoured the transcript and I was like, phew, he never said that it was a false confession. I'm so glad. So just be careful because future events can occur in your cases, and you just want to think about what's said under oath. But, all right, so unlawful arrest. Miranda's almost dead, okay? Burgess v. Tompkins, Mark, your name's Mark, right?
Joe.
Huh? Okay, good. I'm just make sure I'm right. You're not taking people's names. Mark gave the name of the case. That is the case. Huh?
Joe?
Joe? Oh, Joe. Okay, sorry.
No, that's okay. It's okay. They're close.
But I can't tell you his last name. Joe. I'm really an idiot. Okay. So, yeah, and this guy wants to come practice in Milwaukee. He might be changing his mind now. In any event, this Burgess v. Thompson, because it's really, really bad for Miranda. Because this guy was read his rights, never signed a form that he understood or waived them. There was contradictory testimony about that at the Miranda hearing. They talked to him for 2 hours and 45 minutes. He said 2 things. He wanted a piece of candy and his chair was hard. Didn't answer any questions. I'm not even sure how much they questioned him because it was unrecorded. They could have just done this monologue. Then at a certain point, the cop says to him, do you pray to God? Yes. Do you pray to God for forgiveness for killing this child? Yes. The interrogation ended 15 minutes later, probably, I would think, because he asked for a lawyer or something like that happened, but it was done. He didn't really give a post-admission narrative, okay? Didn't give a post-admission narrative, and then they end up charging him, and the U.S. Supreme Court says that he never asserted his right to remain silent because when he answered their questions, that was an indication he wanted to talk. In other words, the concept of a waiver is dead. They said this was a valid waiver because he talked. It's really changed Miranda law. Some places have a higher standard for Miranda, a lot of states don't. So if your state follows federal law on Fifth Amendment litigation, you're totally screwed. But there's one area where we're not screwed yet, and that is on whether they understood their Miranda rights. And that's why this whole issue of hiring psychologists to evaluate your client is very, very important. But there's some other things you can do with Miranda, too. You can measure the reading level of Miranda. An undergrad psychology student can do this for you. Measure the reading level of Miranda warnings The other thing that we did in our office was we did have this undergrad guy who wanted to do his thesis, his senior thesis about Miranda, and we gave him all these interrogation tapes, and he listened to them, and he discovered that the rate of speech giving Miranda warnings was much, much faster than the rate of speech of the police officers at the other time when they were interrogating somebody. And this actually makes a lot of sense to me, because when you read something off a card, you're going to talk faster. So that, the reading level of Miranda may start to get you into a better record on this whole issue of understanding and waiving the rights, because that's where I think Miranda litigation is going to move to. We used to win a lot of cases in our office on waivers, because we had a lot of cases where the cops would just read somebody the rights and plow right into the interrogation and never ask them if they wanted to waive their right. But that issue is now dead, at least in federal law, okay? Delays in going to court, that can be another basis. But the big one is voluntariness, okay? Were coercive techniques used? And if you can show coercive techniques, then they are weighed against the vulnerability of your client. Now, there's this U.S. Supreme Court case, it's real old, Frazier versus Cupp, that basically has been interpreted by everybody, by police, by the people who say police are allowed to lie to your client about evidence, or present false evidence, or use vague questions. But Frazier versus Cupp doesn't really say that. It just says that it's not per se coercive to do that, but it's a factor in a voluntary analysis. There are a lot of states have case law that says that gets you over the hump for them to now consider the particular vulnerable characteristics of your client. Because if there's no coercion, the court is never to even reach that issue. So that's important. If you have a juvenile, you may have particular issues about a juvenile being interrogated. The case that led to mandatory recorded interrogation in Wisconsin, the Jarrell case, was a case of a juvenile. And although it was very controversial mandating the recording, it went 7-0. So even all the conservatives said that confession was involuntary because this juvenile was interrogated who had asked for his parents to be there and they wouldn't let him be there. So there's issues around that. And finally, is a confession so tainted, is the evidence so tainted that it's presumptively unreliable? That's really edgy litigation. This hasn't been litigated well yet, but Steve Drizzen from Northwestern wants to really see people litigating this issue. I think it's interesting. I think you're going to draw from case law in other areas about unreliability and taint. And if you want to think about it, call Steve Drizzen. He might have some great ideas for you. Okay, so we'll skip that. What's coercive? All these things are coercive. Lengthy and repeated interrogations. Being held incommunicado, that's from the Miranda decision. Sleep deprivation, physical discomfort, psychological discomfort. This is all legal stuff. So I'm going to kind of pass over that because we only have like half an hour. All right, the motion hearing. Here's the things you need to think about going into the motion hearing. If there's a tape, how are you going to handle it? Okay, working with recorded evidence requires some thought. How are you going to cross the cops? Are you going to call a psychologist or an interrogation expert? Is your client going to testify? And are there any collateral witnesses that can help your case? And sometimes there are. I had a confession suppressed once where the client testified that the cop said if he confessed he could go home. Now what judge is going to believe that? Except that his father was out in the lobby of the police department waiting for him, and the cop came out, the father testified, the cop came out and said, as soon as I get his statement from him about what happened, I'm going to let him go home. And I put the dad on, and the combination of the client and the father, the judge ruled that that was credible, and the confession was in fact coerced. So, you know, strange things happen sometimes. One of the things I always get the records of is how long they've been in interrogation. Sometimes there are interrogations you don't get discovery of. In Milwaukee, at least, every time they move them from the jail to the interrogation room, they have to sign them in and out of the lockup. And once in one of my cases, I was reviewing those cards, and the guy was taken down, and I had no report. And so I subpoenaed the cop whose name signed him out, and he had interrogated him and never written a report, but he had notes in his memo book. So you've got to really thoroughly look for this stuff. Now, the recording. Besides transcribing, don't waive your cross. But your cross can't just be going over what's in the recording because you're going to piss off the judge to the max. If you have a good judge who did her homework, who read the thing and knows what it is, you may want to ask why questions about certain things, but if you just say you did this, the judge is going to be saying, counsel, I read it. I already know what they did, okay? You want to really know it so you're prepared to impeach. And you want to make provisions for the record. And what do I mean by that? When you play a tape in court, and use a transcript, you've got to put into the record that, you know, what the exhibit is, where the time is on the tape that you're impeaching with, and what page number it's in the transcript. You have to remember that for the appellate court. So when I prepare these things, when I have my these things transcribed, my secretary puts a time in every 5 minutes. So then as I'm going later through the transcript and preparing the points that I want to bring out, within a 5-minute reach, I can find it on the tape and get the exact times down. This is really important. So think about that, because a lot of people forget about that stuff. Oh, here's my little thing at the different speeds. Can you guys see this?
Yeah.
All right, we don't have to turn the lights off. It's going to go really quick. But yeah, this is, I knew I probably had it here somewhere. Yeah, I mean, so, you know, you might want to take a look at the tape, because if you can speed something up, if you have a video and you can speed something up, that's really great. I had a case once where my client said that after the cop said, "Do you want to waive your rights?" he said no, and the cop said yes, and honestly, you couldn't really tell this in the tape, it was really muffled. So when I threw the tape on, I played it fast and I played it slow, and it sounded different at different speeds. So when we did the hearing in court, I played them at the different speeds for the judge too, who ultimately ruled against us, but that's another story. He said he took it home and had better speakers through. Oh well. All right. You do want to educate the judge that police interrogation is not a search for the truth. It is a quest for confession, all right? An interview can be a search for the truth, but not an interrogation. In interrogation, there's been a decision, the person is guilty, and a choice to interrogate them, and you want to give them a message. This is a false confession, and this is my ex-husband. Okay, moving right along. All right, when you do these motion hearings, active listening is just crucial, okay? I can't tell you how many times I've litigated these motions, especially this pre-recordation where these motion hearings, literally, the longest motion hearing I ever had once was 2 weeks. Now, granted, the judge did his whole calendar during the 2 weeks, but I mean, you talk about misery, having to spend 2 weeks in court litigating a suppression hearing. I mean, I can't think of many things I'd rather not do than spend a whole 2 weeks on a case, you know, where you can only get like 3 hours of testimony a day. But by the time we were done, the total length of the testimony, I measured it, was longer than the interrogation. But we had to reconstruct the whole thing, so it wasn't that surprising. Active listening. There's so many times where I've looked at these transcripts and I'm just like, damn, if I only listened closer and asked a follow-up question. And in these motion hearings, okay, we're teaching you never ask an open-ended question cross, and I'm a firm believer in that for trial. I'm a real firm believer for asking lots of open-ended questions at motion hearings, really listening to the answer, and then following up on it. And one of my favorite questions in motion hearings is ask why, okay? Ask why, and other follow-up questions. And it becomes really fun, because in these motion hearings, you know, here's a real broad question. How did you talk to my client when you interrogated? I talked to him like he was a human being. Well, what does talking like a human being mean to you? You know, what are you saying? And then they just start wriggling around, and they don't really answer these, a lot of these cops. And eventually, after like hours of trying to pin them down, why they did this, what they mean by this, how they interpreted it, and they're wriggling around, not giving you a straight answer, it gets very annoying for the judges. This is why a lot of judges like recorded interrogation. And the same thing is true about the client. The client's got to be very well prepped. If you don't prep the client properly, they will surprise you with a bad answer during your confession hearing. I promise you that. Okay, now, this is just a little thing I want to show you for those of you who hate writing briefs and love PowerPoint. If your judge loves PowerPoint too and loves computers, instead of writing a brief, maybe you should do your argument on PowerPoint. This is an actual, can you guys see this well enough? Okay. All right, this is an actual PowerPoint I did in a confession case, the one I litigated for 2 weeks that we got suppressed. This was it. I knew the judge liked his computer. He gave me 3 days to write a brief. I did this instead. This was the time interrogations on the different dates. The initials stand for the initials of the police officers who interrogated my client. And then, just in case he didn't like looking at it that way, I gave it to him the more traditional way to show the amount of time he was interrogated while he was in the police lockup. this particular client was a diabetic. So this showed, and I had an expert, I had a neurologist, I believe, was my expert to come in and talk about diabetes and its effect on the brain. And most of the time they didn't take him. In the middle of the interrogation process, after asking him to go to the hospital, they finally took him there and his blood sugar was 451, and if any of you know anything about diabetes, that is like sky high. Because it should be from 80 to 110. They came back, they got him some insulin at the hospital, he never got it again, his blood sugar went up way, way far again, and this is when, the next time it got measured was when they turned him over to the county jail from the police department, and they measured his blood sugar at 306 at that point. So what we were able to show then was when he should have had his medication, as it was prescribed, when he actually got it, and then the expert was able to calculate that the insulin would have worn off, and when they finally wore him down in this very last interrogation, got a concussion, and got the admission and all that, that his blood sugar would have been very high and he would have been very uncomfortable, physically uncomfortable again. So then we did some little, this is my idea of a brief, in this particular case anyways, did some choice quotes, okay? So instead of writing a brief, I just got some choice quotes. Here, I love this Miranda decision, even though it's getting totally undone. I mean, Miranda was substantially weakened by Perkins versus Tompkins in many, many ways. But this whole late interrogation or incommunicado incarceration is strong evidence that they didn't validly waive their rights. There's great, great language in it. And then went through like all of the factors for involuntariness. A lot of these are just very specific to my case. Like the fact that a cop smoked a cigar in the interrogation, my client testified they blew the smoke in his face. You know, oh, and the judge was a real anti-smoking guy, went on a tirade about why would you smoke a cigar in an interrogation room. It was, well, unless you were trying to intimidate the person. That's the only possible reason that you could have done it, you know, and he went, oh, it was hysterical. And then the arms in the shirt, you know, my guy was, because he was a brittle diabetics get really cold, like they'd be freezing in a room like this, okay? So my guy had taken his arms from his t-shirt and wrapped them around his body to stay warm. Well, the cop testified, consistent with the Reed technique, steps 5 and 6, that procure and retain attention, handle passive mood, that he saw it as the guy was drawing, so he made him take his arms out of his shirt so he could be more engaged with him. So that was that all about. The other stuff is more ordinary. So I, you know, then I showed all this stuff, and then I did a chart of other cases about interrogation times and delay, not taking them to court, voluntariness, showing that my case was better. The judge suppressed the confession, okay? Now, there are two really contradictory things in motion cross, two rules. Try not to annoy the judge, okay, if you can help it. They get good. I was doing one of these really long ones. I yawned and the judge said, oh my God, you're so boring. She started yawning. I said, Judge, I'm boring myself, okay? On the other hand, you have to talk to the appellate court. So I'm going to skip this. Okay. When you do a motion hearing, you want to develop chapters that are going to be used in closing. So now what I'm going to go through are the chapters, not the questions, but the chapters. This is for both the motion hearing and the trial. The difference is in the style of questioning, okay? In a motion hearing, like I said, lots of open-ended questions if you don't have a recorded interrogation. Or if you have a recorded one and you're mostly using the transcript and you didn't have like a major litigation in the motion hearing to reconstruct the interrogation, these are the chapters you're going to use in your actual, okay, I'm going to skip that, we don't have time, all right? We're going to, these are the chapters you're going to use. So these chapters go for motion hearings or the trial. Number one, they're familiar with the crime scene. This is really important because if you're arguing it's a false confession, you're going to be wanting to show some contamination getting in there. So the fact that they're familiar with the crime scene in the case, you want to establish that, and they are. I mean, if they weren't there personally, they got it at a shift briefing, whatever. Okay. One of my groups, I talked about how important it is to understand how police operate, police work. It's very important to understand, like, how does the flow of information occur in your department? Is it a shift briefing? Do they write reports, et cetera, et cetera? Training. Training is really crucial, and I'll tell you why. And like when you interrogate police, you've got to go from the general to the specific. So your cross-examination, you're going to do this in the motion hearing, you know, officer, because I will tell you the reason why. They always deny using their training in the read technique. I've never done one hearing, one motion to suppress, or one trial where the cop has said he's used his training in interrogation. They think it's dirty, and they're right, so they don't admit it, and they just say they learned these things on the job. They always do that. But I really like to impeach them. I like to show the training materials how they did this theme development and the false evidence. That's all really important in trying to litigate these cases. So you start out and you go like this. Officer, when you got your job, you went to the police academy, you got some training. You got training in firearms. You know, because knowing how to use your gun is a crucial part of your job. And you're glad you listened to your training, you followed your training, blah, blah, blah. So you hide the confession interrogation part of it, you know, so you pick whatever it is. Their gun, talking to witnesses, collecting physical evidence, how to make a stop. Yeah, and then you throw interrogation in there with this long line of stuff, and they're just kind of going yes, 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 right? So they paid attention, et cetera, et cetera. This is good. So trained interrogation is a part of that, all right? That they're trained and experienced in deception, and I don't mean in detecting deception, I mean in creating deception. If you happen to have a cop who was ever an undercover drug guy, this is a really good topic of cross, how they fool people, he got people to think he was a criminal. In other words, he's really good at putting out an act that makes a good impression on the jury. So, then all this stuff about the weaknesses of the case. You're going to, everything, you know, you're going to look at your case and you're going to say to yourself, if this was the perfect case, you're going to do this anyways, even if there's no confession. If this is the perfect case, this is what the police would have, right? And here's my case, and here's what they actually have. You make a list of all that stuff. So then when you're cross-examining the cop, whether it's the motion or the jury, it's like, let's talk about what you had and didn't have in this case, all right? You had a witness who identified somebody. Now at the time when they were interviewed, they said that the person who did the shooting was 6'2", right? But my client's only 5'8", okay, so you weaken the ID. And you never recovered a gun in this case. So you were never able to find a gun and match it to the forensic evidence at the scene, the casings and the bullet. You did not have any forensic evidence that was left at the scene. For example, blood of the perpetrator, hair, fiber evidence. You know, you just kind of go down the list of all the things that they didn't have. You didn't have a video running of what happened. You have to rely on the witnesses here. So you go through all that stuff. Because the point you're trying to make, then, is interrogation was crucial in this case. Because when you want to argue to the jury that this is a false confession, you know, you can have a jury think it's a false confession, or it's a coerced confession rather, but the other evidence is strong enough to convict your guy. You don't want to go there. So you have to show them there really wasn't much else. They had an opinion that the client was guilty. Now, this is a great question under certain circumstances. If you have any evidence that's suppressed in this case, you don't want to go there, okay? Because it's all coming in. You just opened the door for all that stuff that went out with the motion in limine, you know, because that contributed to the police opinion. Now, you know that an opinion of the cop that your client's guilty is not allowed in a jury trial, right? So you're waiving an issue by putting this question in. But it may be very helpful to you to show that they went in there with no evidence at all, with some ridiculous predetermined idea because they were prejudiced against your client, because they had a word from a really bad snitch and they didn't have their, you know, weren't thinking critically. So you may want this question even though it's not admissible. Their purpose was to get a confession. No cop will ever say yes to this question, but I always ask it, okay? So you went in there and your purpose was to get the confession. It's always going to be no. My purpose was to get the truth. I would bet $1 million that no cop will ever say his purpose was to get a confession. And, you know, I wish somebody would bet me because I need some money. But in any event, so this is what you do. They say, no, my purpose was to get the truth. You already know this is coming, so you're all nicely prepared. It's time for looping in a trilogy. Well, the truth couldn't be, now here's my theory of defense. My client was at home sleeping this time, okay? The truth couldn't be that my client was at home. No, he wasn't at home. The truth couldn't be he was 5 miles from where the shooting happened. No, counsel, that couldn't be. The truth couldn't be that he was in bed asleep when this crime happened. No, that couldn't be. So your purpose was to get a confession. Oh, no, 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 my purpose was to get the truth. So it just shows that they completely, you can have a few rounds of this if you like, you know, depending on how much you want to do, but it really works nicely, that this whole prejudgment. And then the cop looks like a liar. They're not, you know, they're not like owning into the fact that they were trying to get a confession out of the guy, and the jury, they don't like that. All right, interview versus interrogation. Prosecutors will always question the cop saying, did you interview this person, right? They did interview them. This was an interrogation. Those are words I think distinguishes between an interrogation and an interview. So let the prosecutor, did you interview, and then you say, now let me just get this straight. There's a difference between an interview and an interrogation. What you did was an interrogation, not an interview. It makes the prosecutor look kind of bad. I like that. Okay. Details on Miranda warnings. You want to go through that. Maybe the cop, did you know, the officer, that you didn't know that the Miranda warning required a 12th grade reading level, and that my client reads at a 5th grade reading level, if you have that in your case, all right? The physical surroundings, the painting of the word picture, always nice. The interrogation room is small. You can take a masking tape and tape off the dimensions of the interrogation room in the well of the courtroom, and then you can act out your cross. You can reenact your closing in there. Really fun. You can use the pictures. You can reconstruct one. But this is really important, the total police control of the environment. When they went in the interrogation room, it had a door, the door had a lock, you had the key. Only you had the key. If my client wanted to get out of that room, you had to open the door. If you and your partner left to go have a conference, because they often leave and leave the person in there, he couldn't get out to go to the bathroom. You had to come back and get him out. In fact, he couldn't decide when to go to the bathroom at all. Only you could let him go to the bathroom. He couldn't decide when to eat, when to sleep, when to lie down. You know, just think of all these things to build this word picture of the total police control of the environment, to make a phone call, to talk to a loved one, whatever, okay? And then time. Long interrogation times. Take a watch, have the cop hold it, a good watch with the second hand, and have the courtroom remain silent as he counts out 60 seconds silently and tells you when it's over. Of course, it will seem interminably long. And then just multiply how many seconds existed in your interrogation and say, there were 2,944 more of these, weren't there? That's a real nice way to make time come alive in a big way, besides the charts. Then you want to go through the denials. You know they've cut them off. And again, if you have it on tape, then you can use the tape. How about the fact that the police have specialized legal knowledge? You know, when they're manipulating the situation, they're the ones who can suggest accident or self-defense, or not suggest accident and self-defense. They know what the law is, they're trained in it, and they can lead the interrogation a certain way because of it. They ask leading questions, opportunities for coercive conduct, and then this is really big. Any vulnerability your client has, you'll have discovered in the motion hearing. You're going to ask about this. The cop doesn't know. For example, my guy, my poor kid with the diabetes, you know what one of the cops testified to in the motion hearing? The client said he had diabetes and he thought he might be uncomfortable, so he offered him a candy bar. I'm like, oh, dude, you don't know anything, do you? Okay. Then you're going to go through the bait questions and the false evidence. All the stuff and you're going to spend most of your time on the themes that were developed. You're going to really go into this open-ended in the motion hearing, and you're going to know what this is to cross close-ended, how they developed these themes to manipulate the situation, and the alternative question if they used one in your case, what they did. And then you're going to contrast the theme development stage with the post-admission narrative, because the post-admission narrative is done to try and actually get the details more like what the real crime is. So the theme development stage looks a lot different than the post-admission narrative. And you know, one of the things they use in the Milwaukee police is you got to really decide what you want to do for the rest of your life. Yeah, dude, you did this homicide. You're going to be spending the rest of your life in prison. I mean, it's ridiculous. But you start showing how they were inducing people to confess. You're going to contrast these themes. I don't have time for that video, but there's a real interesting video on YouTube of police actually feeding details of a confession. This is a case from Missouri. So if you want to put in YouTube, have you ever had a cop in your face, you will find this video that I'm skipping. All right, then you're going to impeach them with training materials. So what's going to happen is you're going to cross-examine the cop in your motion hearing or your trial about all these read techniques, and they're going to say, I never used it. I never did this, I didn't use the read technique, I didn't do this, I didn't do that. If you have the tape, you're going to be able to show them how they developed the themes, you know, exactly what they did. If you don't have the tape, though, it's a lot rougher. So if your client's going to testify they use these things, and they're denying it, remember when they said they used their training? Okay? Well, then you're going to take out your training materials, and you're going to impeach them with it. You're going to say, now you were trained, you know, an officer, you previously told us that training is important, you used your training, you followed your training, because you know now they're saying they didn't, and your training materials talk about theme development. In fact, they have specific themes for homicide cases. They specifically talk about planting this scenario or creating this impression. You know, and you go through that whole thing, and you impeach them with the training materials. And for you as the defense lawyer, you're in a win-win. If they say they followed their training, but earlier they denied it, it's great, the cop is lying, okay? If they stick with, I didn't follow the training, then they lied earlier. If they say they didn't follow the training, the jury doesn't like them. What juror wants an untrained cop doing important police work on high-end cases, you know? A cop who doesn't follow his training. Well, no wonder why we got a false confession, ladies and gentlemen of the jury, okay? You can hear your closing argument there. You're going to use the statements. If there were denials, they weren't followed up on. And then again, contamination. Like I said, you have to show the source of contamination. And in a lot of these interrogations I listen to, the police are suggesting details because the person is denying it, so they keep throwing more and more information into the interrogation process to get the confession. So it's going to be in there. You want to show that it's inconsistent with the evidence, and if you have one of these remorse letters and the crossouts, how all that stuff was totally manipulated. You want to use the tapes. There are a lot of parts the prosecutor will play the confession. You want to use the interrogation. The prosecutor will not play those parts in court, okay? And you're going to show that it's different from the direct exam then, and contrast this, and talk about, and sometimes they have tapes and they have a written report, and the written report summary is not accurate as to what's on the tape, and you can show the difference there too, and that's really fun. I don't really have time. Obviously, impeaching with the tape is something you can do. You need to be prepared to do it. Don't futz around. Make separate sound files. Have transcripts. When I impeach with the tape, I have somebody usually helping me. I've prepared these little points of impeachment, and I say to the person who's co-trying the case, play number 3 or, you know, whatever it is. I walk up to the Elmo, I put down the transcript so the juries can read the transcript while they listen to the tape. That's important because the sound isn't that good on these things. Okay, I don't have time for that either. But obviously you're going to go through that tape, you've got to love that tape, you've got to know that tape, you're going to have to use it to show what's going on, and the investigation ended. In other words, they didn't do what this good police work is. If you have this, if the investigation ended, they didn't go out to verify stuff, that's a really helpful fact in your case because their training materials talk about how they should do that. And then it's really fun, the closing. You can replay what happened. Okay, you know, we just might win that trial today. I'm sorry I got you guys out only 2 minutes before the next talk. I should have been giving you a break. So, you mean I could have talked 15 more minutes and not have rushed through this? I could have showed you more videos. Oh well. All right. I'm glad you guys enjoyed me. I mean this. I enjoyed it too. In any event, I'm glad you guys enjoyed this. If you have questions about your confession cases and you need some help, I, like every other member of the faculty, is available. So, you know, call me, email me. You know how to get in touch with me. You know how to find the written material if you need them. But get in touch, and I hope to see you guys around at maybe an NACDL meeting or some other place. But it's really been fun, and for those of you I had in my small groups, I really enjoyed meeting all of you. Thanks a lot.
Nobody looked over.
Joe, I am so sorry.
That's okay.
I'm such a space cadet.
No, don't worry
And
about
I do
it.
know your name, and I'm just like an idiot.
No, don't worry about it.
So you can just say Vishney was having a senior moment up there.
That's the kind of impression I made.
No, it's the kind of impression I made. Everybody knows you and loves you now because you're the guy. The whole faculty loves you because we all empathize with you after being tortured by Joe Johnson. I mean,
I appreciate that. Well, hopefully there'll be somebody next week.
okay, so call me when you come into Milwaukee the next time.
I will. I will.
Yeah, call me, and if you do apply for a job, if you can handle the low pay, make sure you get in touch so I can bring attention to your application.
I appreciate that. Thank you.
Okay, sure.
Like he, she,
He said he suffered from the Joe